We have 6 items on the agenda today, and before we turn, I'd like to take a moment to recognize that we are going to adjourn in an earlier fashion in honor of Senator Bob Dole, who will lie in state in the Capitol today and whose arrival ceremony takes place this morning. Senator Dole's war record is well known and so widely admired. The courage this man showed, the price he paid for his service to our country. I particularly remember, as a member of the House, his extraordinary leadership on the Americans with Disabilities Act, and the fact that I had a chance to work with him only one time when he returned after he left the Senate, but he returned to help in 2012 to pass the Convention on the Rights of Persons with Disabilities, a treaty that protects the rights and dignity of individuals with disabilities, which in the Senate, unfortunately, was narrowly rejected. His legacy lives on in a more inclusive society that he fought to create, and America is better because of Bob Dole and his service to our country. With that, I'll turn to our agenda. 4 nominees have been listed for the first time, will be held over. Bridget Brennan, Northern District of Ohio; Judge John Chun, Western District of Washington; Charles Fleming, Northern District of Ohio; and Judge David Ruiz, Northern District of Ohio as well. We also have 1 U.S. Attorney nominee on the agenda, Dawn Eisen, nominated to the Eastern District of Michigan. I understand we will be able to voice vote Ms. Eisen's nomination, which we'll do shortly. We have 1 bill on the agenda, S. 2614, Open Courts Act of 2021. The bill sponsored by Senators Portman and Wyden, myself, and Senator Hawley. It's known as the Free Pacer Bill. Presently, litigants in federal court and members of the public have to pay to get access to public federal court records, like filings and briefs, through the Public Access to Court Electronic Records, or the PACER system. Big law firms have no problem, but these fees may be too expensive for individuals, small businesses, small law firms, and nonprofits to track litigation that impacts them. And for some low-income individuals, the cost of assessing records can be so high that it may prevent them from going forward with a meritorious lawsuit. In addition, the PACER system is not keeping pace with reality and technology. Its search function is torturous. There's no uniformity in filings from all 94 district courts and 13 appellate courts. It's time for us to do something. The Open Courts Act will require the Administrative Office of the U.S. Courts to develop a modern, secure, publicly accessible electronic-based filing system for all public court records. The AO is already working on it. Importantly, this bill would make it clear to the AO that PACER must be free to the public. Establishment of the new electronic system would be funded by a temporary, underline the word temporary, fee on certain high-volume PACER users, annual fees to be paid by each federal agency that relies on PACER. After the system is up and running, its operational costs will be funded primarily by annual agency fees and appropriations. We're trying to strike a balance that ensures there will be adequate resources for this effort while creating the correct incentives for efficiency and access. I'll offer a manager's amendment to adjust the funding mechanism, incorporate some technical edits suggested by the Administrative Office of the Court, and include other changes negotiated in a bipartisan manner. I believe this bill improves access to justice by eliminating the PACER paywall. It's important, and I hope the committee can move it forward. And before voting on the U.S. Attorney nominee and the bill, I want to recognize the ranking member if he wishes to make any remarks.